Good morning, everyone. As usual, we are back with the knowledge session. Thanks, everyone, for sharing your time and taking out time for this knowledge session. Today, we have our topic LODR compliances and recent amendments, and none other good starts on the subject, Mr. Sudhakar and Mr. Sridhar. Very good old friend of mine, both of you. Both welcome to this panel program of webinar of Mehta&Mehta. Thanks a lot for your time.
Thank you. Thank you. Thank you.
LODR, basically this will be concentrating on recent amendment, because recent amendment, honestly, though it is by number less, but it has a very big impact and it has implications, and that's why we have good panelists who will share their experience, their thought, the impact of these amendments, how it should be implemented so that it can be properly compliant. All that we will discuss. Just to introduce, I need not introduce, both are very well known all over India, but it's my duty to introduce. Sudhakar is fellow member of ICA, Institute of Chartered Accountant of India, and fellow member of Institute of Company Secretary of India. Is also a Charter Secretary, Qualified Secretary of Institute of Charter Secretary and Administrator UK, and law graduate. Is working with Reliance Industry Limited since 2005 as Vice President Corporate Secretarial, and has worked with Burger Paints India Limited for about 15 years. Huge experience. Sudhakar is a member of Secretarial Standard Board of ICSI and Vice Chairman of Expert Committee on Secretarial Standard of ICSI for the year 21, Chairman of Secretarial Standard Board of ICSI for the year 20, regular faculty at IOD and guest faculty at NESM, National Institute of Securities Market, KJ Somaya Institute Management of Mumbai. Welcome, Sudhakar, to this panel, and thank you for agreeing to sharing your knowledge.
Thank you. Thank you,
Mr. Doctor, not Mr. I should say Doctor. Dr. J. Sridhar is become LLB and fellow member of Institute of Chartered Accountant of India and Institute of Company Secretary of India, alumnus of Indian Institute Management, Ahmedabad, Senior Executive Program. He has also done PhD from Savitribai Phule Pune University in CSR. Oh, sir, then you should be again on CSR.
Thank you.
I will surely invite you, sir, that time. He has, you are there. I am openly telling you now, you are there on 26th. Okay. He has 45 years of experience in finance, taxation, secretarial, legal function, including over 42 years in Bajaj Group. My goodness. Currently Vice President and Company Secretary, Bajaj Auto Limited. He is active in ICSI for more than 2 decades, including he was a President of Institute, our beloved Institute, in the year 2000, Chairman of Pune Chapter, Western Region, Founder Chairman, Secretarial Standard Board of ICSI, oh sir, and Chairman of Expert Group of ICSR CSR Excellence Award. Welcome to the Mehta&Mehta webinar, sir. Thanks for your time, Dr. Sridhar. I will now not say Mr. Sridhar, Dr. Sridhar.
Thank you, Dipti. Thank you so much. Thank you so much for the kind words.
Yeah. So now, as I know the topic I introduced, I'll request Mr. Bala and the panelists then to speak 2 minutes on their views on the topic, and then we will start the presentation. Over to Mr. Bala, please.
Good morning to all of you. I have a pleasure in welcoming you all to this webinar on my own behalf and also on behalf of Mehta&Mehta. Today's webinar needs no introduction at all because LODR is the one which is ongoing compliances for the listed companies. And during the year 21, the LODR has seen n number of amendments which have come one after another, almost about 6-7 amendments which have come. And finally, in January 22, a consolidated LODR notification has come. What is this? All amendments are aiming to is enhancing the responsibility of the directors and especially the independent directors, giving a more responsibility, and also enhancing the responsibility of the various committees in which independent directors required, and also increasing the strength to the level of 2/3 of the independent directors in many of these committees. And in addition to that, there is a topic which you are all aware, related party transaction. The related party transaction is the one which is actually a very, very big, vast subject, actually, really speaking. I don't know whether we'll be able to cover everything, but the focus today is basically to concentrate the amendments which have come in respect of the directors, in respect of the related party transactions, and also in respect of the committees and other related amendments. We will not be able to cover all the amendments, but specifically we are taking a time period. The amendment which have taken place between May 21 to January 22. That is what we are actually going to cover it here. During this period, there were actually debt listing also has been brought on the LODR, various regulation, etc. Since we had the separate seminar in the last week, I think we will be touching upon the amendments here, but that won't be a discussion part of it here greatly because we had a separate session on that. I think with these few words, I will actually request panelists to spell out their thoughts before we start the program. Over to Sudhakar, please.
Thank you, Bala. Thank you very much. In fact, at the outset, my sincere thanks to Mehta&Mehta and Dipti in particular that for inviting me for this webinar. And so that I can also learn definitely from the discussions what we are going to have. Having said that, unfortunately or fortunately, of late, the kind of amendments which are coming, whether it is SEBI security laws or Companies Act, it is unless until these kind of webinars are there on weekly basis for professionals like us, and especially the budding professionals, it is very, very difficult for them to keep the pace with this. In fact, with this kind of experience, at the panelist level, we are struggling still, to keep the pace with these kind of amendments. Sometimes I really feel very sad for the budding professionals, that several times they get sometimes confusing, sometimes, that getting even, in fact, recently in one of the forums, some company secretary was telling me, sometimes I get demoralized because I'm not able to keep pace with the changes, what I have to do for that. I said, join Mehta&Mehta webinars like this, and corporate professionals are doing in the Friday evening and Mehta&Mehta doing on Saturday mornings. So in fact, apart from this thing, jokes apart, there are a lot of things or even the ICSI is doing, which are available on the YouTube also, so that in case, even if we are not able to actively participate, we can definitely watch at leisure and can learn. This is what at least I am doing it from this side. As far as the regulators are concerned, I don't know that why these kind of changes, why can't they come with the changes at one particular quarterly once or half yearly once, something like that. The moment something happens, the kind of knee-jerk reaction, they bring something or the other. No proper thought process is going in that. A lot of scope is being left for the interpretations. And it is not like that, we are doing it for the first time. Every time, whenever something or the other happens, it is leaving a lot of scope for interpretation. But the good part with SEBI is that whenever they bring any kind of changes, they give at least approximately about 90 days before they incorporate and implementing those changes. Of course, at the same point of time, the regulators, I must appreciate and place on record my appreciation. They are listening to the industry, which was not there at one point of time. These days, whatever the difficulties are there, regulators are taking the corporate into confidence, and to a large extent, they are understanding the difficulties and are also making the necessary changes wherever it is required. I think with this, I will give a pause here, and when we are discussing it further, I will express my views. Thank you, Dipti. Thank you, Bala.
Mr. Sridhar?
Yeah, thanks, Bala. Thanks a lot, Dipti, for giving an opportunity to share this morning session with all the company secretaries here. And I think as Mr. Sudhakar mentioned, I think we are that way going through some tough times. I think every month we are coming out with a lot of amendments to various regulations. All the regulators are hyperactive. SEBI in particular is hyperactive. And I think at every board meeting of theirs, they would like to come out with some very solid changes, and probably they are also under pressure from various other stakeholders like the finance ministry, or maybe from the proxy advisories, the financial, the FIIs, the FPIs, and so many others. So, and then again, there are some scams also which keep happening from time to time. So they have to plug the loopholes. And then the problem that we always face is that just because of few black sheep, everybody has to suffer through and go through all those tough regulations. And it becomes quite tough for the others who are very honest, and then who already have good systems in place. For them to go through further complications and further compliances is sometimes a little big burden for all the corporates. And in fact, I happen to be a member of the task force in that of SEBI, where when we had discussed about these RPT changes, and I could get some inside views of how they go about various rule making or amendments and so on. And of course, they had representations from corporate sector also, no doubt. But the majority of the members in the task force, you will find, are are from the stock exchanges, proxy advisories, and of course from SEBI being the chairperson of the task group, and some of the others from mutual funds and others. So the bias is very much there for extra compliances to have greater checks and balances. So even if from the corporate side, we try to bring out certain balancing in that, but many of the provisions do come in which are very tough for the corporate, and they finally conclude that, yes, I think let us try it out. And if there are too many objections, then we will see what happens. So for example, now, of course, we will be discussing all this in the coming hour or so. So there are quite a few issues in the RPTs, which I could also notice. Mr. Sudhakar also has noticed a lot. Bala has noticed. Dipti has noticed. So there are, of course, we have to go through all these things. But it is good for the professionals also. They have to keep pace all the time. So they have to keep working hard. So with these opening remarks, I would like to hand it back to Bala. Thank you.
The importance can actually be seen by looking at the participants here. The participant number is showing something about 188.
Yeah.
So
Sudhakar and Sridhar, 2S is joined. What I can say?
Yeah. Not only that,
I must say it is commendable. It is commendable.
It actually shows what is the importance of this particular topic, and also eagerness to learn and add the knowledge of the expert people like Sudhakar and Sridhar over in the field over. That is what I would say. Salute both of you too, sir.
And hats off to Dipti for taking this initiative and having all these programs every week. Fantastic.
Yeah, thanks. Luckily, we are getting every time more than 150. That much we are getting every time. But you are adding now. Okay. You two are adding to this. Okay. Thanks, everyone. Charmi, you can start the presentation, please.
Yes, so good morning to everyone of you present here. So today we will be talking about LODR compliances along with recent amendments. So starting with the introduction, as we all know, SEBI has come up with several policies and initiatives in order to not only regulate the Indian capital market, but also align the capital markets. LODR is one of the most important regulation, as it is mandated by SEBI to enable transparency and fair disclosures by all the listed entities in India. SEBI LODR regulations are a good mix of principles and rules-based regulations. In case of any ambiguity between any principle and regulations, the principle shall prevail. Listing regulations were notified with a twin objective. The objectives were like aligning clauses of listing agreement with Companies Act 2013, that is to have a single listing agreement, And the second being to consolidate conditions under different securities listing agreements into a single one, so that we can ensure greater regulatory enforcement. So what is the meaning of a listed entity? According to Section 2, subsection 52 of the Companies Act 2013, a listed company means a company which has any of its security listed on any of the recognized stock exchange, and to which securities these regulations are applicable. It goes as these regulations shall apply to all the listed entities for any of the following designated securities on recognized stock exchange, which includes securitized debt instruments, security receipts, units issued by mutual funds, any other securities, and Indian depositories, depository receipts, NCDs, NCRPS, perpetual debt instruments, and perpetual NCPRs. Then specified securities which are listed on the main board or SME exchanges or institutional trading platform. So now we'll be talking about the amendments which are pertaining to the provisions of directors. So this amendment has come up on 1st Jan 2022, which says that the regulation 16, subregulation 1, clause B, point 5, association with company of relative of person who is being appointed as an independent director. So earlier, the provision had that none of whose relatives is holding securities or for interest in the listed entity or its holding subsidiary or associate company during the 3 immediately financial years or during the current year. So now the provision has been amended by saying none of whose relatives has or had any pecuniary relationships or any transactions with the listed entity or its holding subsidiary or associate company or their promoters or directors amounting to 2% or more of its gross turnover or total income of 50 lakh or higher amount as may be prescribed, whichever is higher during the whichever is lower during the 2 immediately preceding financial years. So the impact has been that the threshold of interest has been prescribed and scope previous years has been limited to 2 years instead of 3 years now. And earlier the provision had said the only whose relatives are currently holding the securities, but now they have also made it to who are currently holding and also hold the pecuniary relationships and transactions with the listed company and their holding subsidiary or associate company.
1 minute, Charmi. Panel, your comment on this amendment. Go to earlier slide.
Yes, sir.
Because it has a big impact. So
Yeah. Sudhakar would like to.
Go ahead, Sridhar, go ahead. See, according to me, this particular thing, this is basically a change in the definition. There is not much to interpret or to discuss like that. But certainly, I have some views to express as far as the independent directors are concerned. Once Charmi completes after this regulation, I will certainly say about the independent directors. And if I say, I can right away mention about that also, because about the appointment of independent directors, right? There is a confusion there, in fact, which we have dealt with very aptly in the guidance note to independent directors.
yeah,
I don't know whether I can discuss that here. I will just in 3 lines I want to say about that.
Yeah, please.
Sure, please go ahead.
Yeah.
Please go ahead.
Yeah. See, as we all know that Section 149 says the appointment of independent directors is there for 2 consecutive terms of 5 years each. The word consecutive terms is very, very important. And up to 5 years. These are the 2 words which are very important. There is a confusion that some people think if I appoint an independent director for a period of 2 years initially, I can appoint him for the remaining 3 years subsequently. Then I can appoint him for the second term of 5 years, which is not so. Whether up to 5 years means you can appoint the independent director for a period of 1, 2, 3, 4, 5, whatever the years you want to appoint, but it will be counted as 1 term. Even if you appoint for 1 year also, it will be counted as 1 term. Whereas if you see in case of the auditors, they said the appointment of auditors is from the conclusion of this annual general meeting up to the conclusion of the 6th annual general meeting. In case of auditors, they cannot be appointed for a period less than 5 years, which is possible in case of independent directors because of that word up to 5 years. Second thing, now first term, when you are appointing the independent directors, it is the board's prerogative to appoint him as an additional director, designated as an independent director. And subsequently, he can be approved by the shareholders as an independent director. But that 5-year term will be counted from the date of the appointment by the board of directors. Now, question comes about the appointment for the second term. Can the board of directors appoint for the second term? Which is not so. If you go to 149 subsection 10, it clearly says such independent director is eligible on the approval of shareholders for a second term of 5 years. So board of directors cannot appoint for a second term. So what we have to do is, before the first term expires, the independent director is to be approved by the shareholders. Suppose, say, for example, for whatever the reasons it is, the approval of the shareholders has not been sought, and there is the first term expires. Can the board appoint him for a second term again as an alternate director, additional director? Answer is no. There is some companies have done this thing, but if you see the guidance note for the independent directors, it has been very comprehensively dealt with. My request to all the participants is to kindly go through this. Why it cannot be done? What is the rationale for this thing? It has been very clearly discussed. Because being a part of the expert committee as well as the Secretarial Standard Committee, I am prerogative and privileged to have that discussions. And very clearly we brought out this rationale. So I thought of taking this opportunity to bring it to the notice of all the participants as far as this particular business. Thank you.
Just I want to say that if you see the definition earlier, it was related to holding securities, but now it is saying whose relative has or had pecuniary relationship or transaction. See the difficulty. See, securities, when you say, you can trace it. Has or had pecuniary relationship or transaction. And see, it is single transaction also they are talking. So I am thinking this is tough to establish. Amounting to 2% or more of its gross turnover or total income or 50 lakhs rupees or such higher amount, whichever is lower, during 2 immediately preceding financial year or during current financial year. My concern was this holding, pecuniary relationship or transaction, the difficulty in establishing and finding for the relatives.
See, in fact, here it is the independent director's responsibility that to disclose.
Yeah.
Okay. Now the question comes, unfortunately or fortunately, the definition of relatives as against 52 relationships at one point of time, which we used to have, it has been brought down to 8 relationships. Okay. But still there also, the question is, how about my siblings' activities? How I will come to know is a big question, right? But having said that, to the extent possible, the director has to take care of all the what's called as precautions to give the disclosures to the best of his knowledge, number one. Subsequently, if he comes to know anything, there is a kind of conflict of interest anywhere and all, he should not put it under the carpet. He should bring it to the notice of the board. In fact, in one forum, I have been asked, suppose subsequently, if the independent director comes to know because of some information which he came to know, he is losing his independence, what he has to do. I said, in fact, governance point of view also, or otherwise also legal point of view also, he must immediately brought to the notice of the board. And he said that, look, my independence got affected and he should lay down his office. He can offer that he want to discontinue as a director as such. However, it is the, on the company's part, if they want him to continue as a director, non-independent director, it can be done. Otherwise, he have to do it. Because that independence of the independent director is not at the time of appointment. It should be continuously and consistently to be there on day-to-day basis. This is a very, very important thing. In fact, sometimes people think that only at the time of the transaction only we have to have that eligibility criteria, which is not so in case of independent directors.
Now so they are covering previous 2 year and current financial year, 3 years.
Yeah, you're right.
No, Sudhakar, you're actually absolutely right, because it has to actually come with it. In fact, in my practical life, I have come across with some of the people. I don't know what is my brother is doing. How can I know? How can I be responsible for that? These sort of the things also I have seen in my practical life.
Yeah.
The-
Only thing they will
Yeah.
expect that if there is any transaction with the group company or with the holding or subsidiary associate company or the promoter group, they expect you to know if the relative is involved
Right.
or if is so
Correct,
they
correct.
that is
The
there.
only thing is, if it is South Indians, it is very easy because the surname is very unique to a large extent. So with the surname, you can capture it. But if it is in that North Indians or with in the other places, it is very difficult. Say, for example, if it is Dipti Mehta and some other Mehta is there, whether they are related or not related, it is very difficult to find out. But if my surname, if you take it Saraswatula, very exceptional things it will be there. The moment that surname is there, immediately you can catch that and can find out whether he's related or not related, whether he got any transactions or not. This is normally I give an example. In case of South Indians, it is very easy to capture, but not for other.
But I think the only way out.
I can say.
I think the only way out, I think for the professionals would be to take a declaration from the independent directors saying that, of course, we do take every time, and that has to be taken and ensure that they give a clear-cut declaration saying that they are meeting all these requirements.
Yeah, but
Sir,
the thing,
in fact, there is
here
one
the
more,
problem comes. No, director say, boss, I mean, like in the chat box, the question is there that if they are unable to get information. So nowadays, directors are telling, as per the best knowledge, information, and my best effort knowledge, there is no transaction, because they
see,
say,
in fact, Dipti, one more suggestion I have given is that you can always take the PAN numbers of the relatives to the extent possible. You may not be knowing the transaction, but you must definitely be knowing what is the PAN number of your siblings,
right,
and your relatives. That PAN number, you give it to the company, rest they will do it. Because with the PAN number, you can trace everything nowadays.
right. I am not able to trace, you trace. This is PAN number.
Yes.
I think Rohit has rightly signed. Mr. Rohit, you want to ask something?
Yes, sir. I have a small question here. The requirement of appointing Holdco's independent director on a material subsidiary on crossing 20% consol income. Do we read that provision as an immediate requirement as soon as the board of directors of both Holdco and subsidiary have adopted the financials and the 20% is getting triggered? Or is there a period of 3 months like we have for the Holdco?
And in fact, if I am not wrong, that periodicity is not mentioned there. So wherever, if the time is not given, means it should be as early as possible. So given this thing, I always go before you close the financials. It is always advisable to have your independent director of the Holdco on the subsidiary.
Correct. I think I also agree, and I think in any case within a period of 3 months, I think it should be done. I mean, we can't go beyond 3 months.
But earlier the better.
Earlier the better. Earlier the better.
Yeah, earlier. Yeah.
Understood, sir. Thank you.
Okay. Go ahead, Prachi. Presentation, please.
So continuing with the earlier presentation, like if none of the relatives should hold this for or has held the position of a key managerial person or is or has been an employee of the listed entity or its holding subsidiary or associate company or any company belonging to the promoter group of the listed entity in any of the 3 financial years immediately preceding the financial year in which he is proposed to be appointed, provided that in case of a relative who is an employee other than key managerial person, the restriction under this clause shall not apply to the relative's employment. So here the impact being the proposed independent director shall not be a KMP in any company belonging to the promoter group in preceding 3 financial years and current financial year. However, the relative of the proposed independent director is not barred from being employed in the company. Moving further, explanation has been provided under Regulation 16 Subregulation 1, which says that this explanation has been provided, which is applicable to also high value debt listed entity regarding appointment of independent directors. In case of a high value debt listed entity, they have also included which is a body corporate and also which is a trust. So now the high value debt listed entity is not required to appoint additional independent directors in order to comply with the provisions of LODR. However, the non-executive directors appointed pursuant to provisions of the regulatory laws shall be deemed to be independent directors for the purpose of LODR regulations. Coming to regulation 17, subregulation 1C, which relates to regularization of additional director or manager. Earlier, there was no such provision in the LODR regulations, which now has been added, saying that the listed entity shall ensure that the approval of shareholders for appointment of a person on board of directors or a manager is taken at the next general meeting or within a time period of 3 months from the date of appointment, whichever is earlier. So the impact being that the additional directors or the managers have to be regularized within 3 months of such appointment or in the AGM, whichever event falls first.
This was required, otherwise after AGM, additional director was appointed and he will be director without any appointment from member for entire year. It was a welcome.
No, but if it is allowed, they should have continued to allow it. I mean, there was no need for that change, and I think this is putting an unnecessary restriction. And I think the earlier provision was quite all right. And I mean, it's not that some company wants to delay the appointment of the shareholders or something. And it is, I mean, it may just so happen that somebody is appointed in October or maybe November or something. It doesn't mean that they are deliberately done it to have that person for 9 months or 8 months, etc. So I don't think this was really required. This is definitely not something for ease of doing business. And for example, just of course, this manager they have added because the earlier manager was not getting covered because they had mentioned only about the directors. And so manager they added it, of course, just to complete that particular drafting. But otherwise, somebody has to have a postal ballot or a general meeting within 3 months from the date of appointment, which is quite an unnecessary burden on the companies, which I think was not required.
Not only that, it also got quite a cost also.
Yeah, a lot of cost, and
cost,
it's very technical, and in any case, it's going to be approved. So whether it is a matter of 3 months or 6 months, what difference does it make?
Correct, you're right.
No, Mr. Sridhar, I think this is scam because there were certain companies that they know that there cannot be, there may be shareholder approval problem. So this kind of person used to be appointed as additional director. He will hold the position till AGM. Fine, he will not be appointed.
No, how many companies would do that actually?
I know. It's like for 1 or 2 companies.
Yeah, exactly. So just 1% or 2% companies have misused that provision. Then 98% unnecessarily have to plan out so many things. You appointing a person at a particular time. So it's unnecessarily now. One will have to time the appointment maybe sometime in April or May, so that the AGM is following within 3 months, so you have it, etc. So all that unnecessary timing issues come in, which should not have been the case.
So somebody is asking whether this is regulation of additional director within 3 months also applicable for unlisted public company. This is LODR.
It is only for the listed entities. Yeah.
Listed entity.
I want to add 1 or 2 things here, because I have seen some questions in the WhatsApp groups that whether this regulation 17(1)(c) is applicable to the category of director or not. Say, for example, nominee director, woman director, independent director, like that. It is very clear that the wording is that for appointment of a person on the board of directors, it means that this particular regulation is applicable to every director who has been appointed on the board for the first time. Number 1. Number 2, that there was another question also coming up, is that suppose this rule is effective from 1st January 22. There is also a question that suppose if an additional director was appointed prior to 1st January 22, whether it is to be done within 3 months, the approval is to be taken or not. To my knowledge, the regulations are always prospective, not retrospective, unless until it is said so. So one interpretation can always be taken is that only the appointments from 1st January 22, this regulation is applicable. But
Right.
having said that, it is always advisable that to take this approval instead of waiting for your meeting in the September. Tomorrow, the regulator may interpret it in a different way. So it is always advisable to have that shareholders approval, maybe by way of a postal ballot and all that, because this is only a transitional provision. The clarity is not there, so it is best, it is advisable, but there is a strong case that it can always be said that regulations or any amendments are always prospective to the rules or regulations. So one different interpretation can be taken is that only the appointments after 1st January 22, this regulation is applicable as such.
Okay. And I also agree. And at the same time, suppose, I mean, technically, somebody who has been appointed in October or November, technically he can be appointed in the following AGM. But at the same time, you suppose somebody is appointed in January, and if he is going to be appointed by the general meeting in say April, somebody who is appointed in October, it will not be logical to have the approval in July or August. So from that angle, I think although it is prospective, it should be 3 months from 1st of January. So even if the appointment is made prior to 31st December, so before 31st March, I think the regulators would expect the person to be appointed.
Yeah, there are certain questions regarding independence and directors that, if time permits, will take on later, because independent director, wife and all that LODR related at present, it is not there. So we'll take it later. And there is a twice question raised whether change in designation from WTD to MD trigger regulation 17(1)(c).
No.
No. Okay. And there is
I will give the rationale for that. When I said no, it is because it is for the appointment of a person on the board of directors. So what the question is about changing the designation.
change in designation.
Yeah.
Right. Yeah. Whether additional director is also required to be regularized in the ensuing AGM. If we are doing this permission, then you don't require it's regularized. Whether applicable for reappointment for second term, does appointment include reappointment? Mr. Sudhakar has already replied first appointment and second appointment, right? Sudhakar, you are covered earlier only.
Correct.
And regulation within 3 months. All other are, I think we have covered. There is one question: what if an independent director's spouse was also an independent director of same listed entity before his appointment? Does this affect his independence status?
Now, what is the question? I couldn't.
No, it should not. It should not.
Okay. The question was, a director to be appointed as an independent director, the spouse of that director before that the appointment was also independent director in that company, listed entity. Whether
there is no bar. There is no bar.
Yeah, very intelligent thing.
So both Atul and Dipti can join as independent directors of one company.
Okay, I think that is all we cover. Okay, something. What will be effective date of appointment for counting?
I think just Dipti, if I am not wrong, we can have this kind of lighter moments also. Am I correct? Because this is
of course.
Informal area, informal. I think forum.
Yes.
What happen is serious discussions. It is very
No.
You're most welcome.
Yeah, it is continuously like that, and our participants are also active in answering the question also. That also is very interesting in our webinar.
Very good, very good.
Yeah, that's good that Dipti and Bala have given the permission. So we can go ahead, Sudhakar.
So what would be the effective date of appointment for counting the period? Date of board meeting or date from which he is being appointed? I think Sudhakar has answered board meeting.
Yeah, it is the board meeting day. It is the first appointment.
Participants, be attentive. Sudhakar is answering everything. Okay. I think we have covered everything. Yeah. Charmi, start.
I have a question, please.
Yeah, please.
Yeah, I'm Lochan from Kolkata. First of all, very good morning to all. I was asked this active that question was asked by me Suppose our director's tenure is completing on 31st March 2022. Now we have proposed a board meeting of 15th March, wherein we have to reappoint them again for the next tenure of 5 years, effective from 1st April 2022. Now, I have a question. This tenure shall be, in my view, it should be applicable 3 months from the date of 1st April 2022 and not the date of board meeting, because he is already appointed till 31st March.
Sir, to answer your question, I have already answered this question. In fact, you said that your independent directors, the first term is getting expired on 31st March 22. If you want to appoint them for the second term. Pardon?
These are whole-time directors.
Whole-time directors. Okay, okay. Sorry, I thought it is independent. If it is a whole-time directors, that for the reappointment 17(1)(c) is not applicable.
Not that means we can reappoint on the AGM also.
Yes, you can obtain the shareholders approval because you are, see, actually, in case of whole-time director, you would have taken the approval 1 year before. How can you do that now? Because whole-time directors appointment is always the remuneration and everything is with the approval of the shareholders. You would have taken their appointment 1 year before, in fact, because you would have taken it in the last, what's called AGM itself.
No, but it can so happen that suppose somebody is appointed from 1st April, say 22, as a managing director, and the appointment may actually come up in the shareholders meeting only in June or July. So here that period of 3 months, I think, would apply.
But this is the second term, he says.
Whether it is first term or second term?
Second term is telling.
Whether, I mean, irrespective of that, I think within 3 months, I think the shareholders will have to approve.
I am also in the same opinion because you see the wording of 1C, the listed entities shall ensure that approval of the shareholders for appointment of a person on the board of directors is never segregated, is independent directors only, sir. So when a tenure is expiring on 31st March and he is being appointed on 1st April, then I believe this 3 must also be applicable here.
And whether the 3-month period will count from the date of the board meeting or from 1st of April is his other question.
Yeah, in my opinion, it should be 1st April because here it is written date of appointment. Date of appointment is on 1st April. Till 31st March, he is already appointed. He is a managing director already in the board, being by the approval of shareholders. So board is considering on 15th March, but his appointed is effective from 1st April only.
I think technically, in my view, I think up to 30th June should be fine. I think in this case, I think Sudhakar can give his views also.
The only thing is, as I was mentioning, whenever the managing director, whole-time director's reappointment is there, we always ensure their reappointment before their tenure expires. So that's why even in the Act also, if you see earlier, you would have reappointed them 2 years before. Now under the new Act, it has been cut down to 1 year before that. Okay. So now this is a very peculiar situation. He says that term is going to get expired on 31st March and they have to reappoint them for another period of 5 years. Okay. So now whether it can be done, I'm not very confident about it. I need to look into that. Kindly, you just check that thing.
Yeah.
So as far as applicability of regulation 17(1)(c) is concerned, the way the wording is there to a large extent, my view is it is applicable at the time of appointment. Okay, though we say that appointment includes reappointment, but in this particular case, as I was mentioning, that whether it is a executive directors or independent directors, before their term expires, their appointment should have been in place for the next reappointment. 17(1)(c) technically, according to me, is not applicable for that. Having said that, Mr. Trilochan, that you kindly examine that, when it is getting expired, it is always advisable by abundant caution, you take it within 3 months. That is good for you. That much I can say.
Yeah, I think that is, of course, erring on the side of caution. But otherwise, technically, I think legally, I think it can be done with effect from 1st April. And the shareholders can approve before 30th June. Under that 17(1)(c) would be my view. Although, as you say, to be absolutely safe, one could do it earlier. But I don't think it is a must.
Sir, Sir Mahesh here. In my opinion, I have seen one practical experience. The Sudhakar sir, whatever he mentioned, that is correct. If suppose the whole-time director or managing director would like to reappoint, it should be on or before 1 year. Otherwise, we'll have to go for condonation of delay.
I don't think so.
What is the relevant provision of this?
So we can say first appointment, effective board meeting 3 months, and reappointment, it can be from the date of appointment, because till that appointment is already made. So the effective appointment will be on the 1st April. So if first time you are appointing, it should be from the date board meeting.
Ma'am, effective appointment may be from the 1st April 2022.
1st April.
But it should be approved by the shareholder and board of directors on or before 1 year ago, before the expiry of the term. Let's
Before
example.
the expiry, yeah.
Yes.
No, the board has to approve before the expiry, would be my opinion. And the shareholders can approve within a period of 3 months. From
3
the date
months,
of
right?
appointment of the
Yeah.
board.
This is general practice we all are doing.
Yeah.
But what Mr. Sudhakar sir has just mentioned regarding the 1 year prior approval, what is the relevant provision? Could you please tell? I would like to go through.
So you have to see definitely provisions of 197 and the rules thereof. Okay. So as I was mentioning to you, whether it is mandatorily to do that, say for example, as I was mentioning, for the appointment of the independent director for second term, that power is not there with the directors. Whether equally it is so for the executive directors, I'm not very sure, but to the best of my this thing, we always ensure that the approval for the working directors is taken 1 year before that. Okay. So that's why I requested you, since I'm not having that particular rules and all with me right now. Okay. And you may kindly examine that. Now, as far as applicability of 17(1)(c) is concerned, what my view is like this, because you want to appoint these executive directors as well as the independent directors before the term expires, you have to also have the shareholders approval in place. So there is no question of, again, applicability of regulation 17(1)(c) for that, because the approval is already there. Okay, it is a continuity. It is a continuity of employment. It is.
Of course, it's slightly debatable. I don't know whether, of course, as Mr. Trilochan, I think
We can park this question and
yeah, we can park this question. We can study it further, but
I think at present, whatever we can say.
yeah, correct.
Yeah.
Correct. I think, of course, I think it is a debatable issue. It is interesting.
Yeah.
But
I would
debatable.
At the concluding my remark, I am really thankful to the way you are organizing this deliberation sort of thing are very helpful. I am really thankful to Mehta and Mehta.
Thanks.
That is without cost. Thank you very much.
Okay, there is a question in the chat box was going on additional director approval within 3 months. So the clarification, once additional director appointed within 3 months, it should be regularized. Still, now the question comes then whether at the AGM again we have to take approval, because he ceases to be director at the AGM. So again he will be reappointed. Right, panelists, any different view?
No, that is correct. You see that here this is really a wonderful question. Here, what is happening is under the listing regulations, you have to take the approval within 3 months to comply with the listing regulations. Shareholders' approval is to be taken. Under the Companies Act 2013, that additional director's appointment is there up to the commencement of the next annual general meeting of the company. So again, you have to go back to the shareholders. This is definitely looks like a ridiculous situation. So they have to bring it at par. But till such time, No doubt about it. In fact, this is a beautiful thing the participant has brought in, because as we all know that whether if it is as far as the what's called compliances of the provisions are concerned, if it is a Companies Act and regulations, both we have to comply in case of listed companies. No doubt about it. Here, 2 times shareholders approval is to be taken. It's a wonderful observation.
They should provide in that then the same do not require further approval or that terms continues. That way the clarification in LODR is required.
Yeah, actually, this is another classic case where Companies Act and SEBI are not in harmony, and where, of course, both can be complied with. Of course, the stricter of the two will apply. We can comply with both, but where complying with one will lead to an illogical situation in the other, I don't think we should do the other part. So, which means if the Companies Act is still saying that it is only valid up to the AGM date, I think that would become a kind of an illogical conclusion. So, I think we have to make a representation to MCA to amend that, or we have to ask SEBI and MCA.
SEBI, I think better.
Yeah, SEBI, I think they should align themselves correctly. And maybe we could just put a note in the AGM notice that for this reason it is being done, but actually it is not required, or something like that. I think we may have to put.
Yeah.
Right. Otherwise, it is coming to ridiculous conclusions.
Yeah.
So, if I may ask, why can't we include the regularization in the third month AGM or EGM in which we are complying with LODR? Why can't resolution be drafted in a way that is?
Exactly. I would agree with you. Actually. Yeah, we should do it in such a way that in that EGM or in the postal ballot itself, it brings out that particular point, and then that point is getting covered. I would tend to agree with that.
Can
I think this can be done, definitely. See that,
actually for that reason only I said no, that once we say that regularization, because it just speak about regularization. So approval of shareholders. So if it is getting, then the person can continue. That way we can carry.
That means that before the AGM, before his tenure, that AGM, if you are taking, suppose if any postal ballot is happening or something like that, if you are taking that approval, I don't think again you have to take it. I stand corrected to that extent.
But still clarification will be helpful.
Correct. Yeah.
Can an MD of a private company whose term is expiring on 31st March 22, can he be reappointed by the board on 25th March 22, effective from 1st April 22? I believe this also does not require shareholders approval.
Yeah, for private limited companies, no problem. Subject to those conditions that in case, if anything goes wrong, then naturally whatever remuneration he has received during that intervening period, he'll have to refund, etc. All those provisions will be there. But of course, for a private limited companies, that problem may not exist.
See, only thing is that private limited companies 197 subsection 1 and 2 are not applicable. Okay, and plus I think 197.12 also is not applicable. But 196, which talks about the appointment, is definitely applicable to private companies. And apart from that thing, even in 197, certain sections, they have used the word a company only. To the best of my knowledge, it is 197, 1, 2, and 12. They use the words public companies. And one more section is there, if I'm subsection, I mean. Otherwise, it is applicable to, you cannot say section 197 is not applicable to private companies at all. It is not so.
Okay.
So wherever applicable, one has to be very careful about that.
Yeah, I agree with Sudhakar, sir. In that case, even if company is a private limited, once we opted to appoint a managing director or whole-time director under section 197.6, then definitely we'll have to follow the provision. That's it.
Yeah.
Actually, this was a practical case.
Sorry, what I want to say here is 197, 1 and 2 are not applicable to the executive directors in case of private companies. Means what? That limits are not applicable. Till the time the private companies are having sufficient profits, they can pay anything to the private company executive directors, because that 5%, 10%, those limits are not applicable to them. But if the deficiency of profits are there or profits are not there, I think that is, if I am not wrong, it is 197 subsection 3 onwards. Then that gets triggered. You have to pay in case of inadequacy of profits or in case of losses. The payment to the executive directors in case of private companies also, you have to go as per schedule 5. Yeah.
Now, we can take this. The question is reappointment, appointment, regularization of additional director. Is this applicable to additional director appointed to prior to commencement of this amendment? We already said it is not retrospective, prospective, but so far possible. Sudhakar has already answered. It should be checked so far possible, right? Charmi, next. Start the presentation.
There are 2 people raised their hands. One is Rohit and one is Hemant. We can hear from them.
Yeah, please.
Hello, ma'am. Under 197, the reference is to 5% of net profit or 1% of net profit or 10% or 11%. That net profit reference, do we read as a previous year audited financial net profit or net profit for the year which we are discussing, that is the current year? There doesn't seem to be clarity under the act. So I request views from panel.
Last financial audited.
Only one small point, since we are discussing on the LODR compliance and the regulations, I think these questions may not probably fit in within this particular topic of today.
Yeah, I will request that, because
otherwise we will not be able to cover most of the
cover
points.
everything. I was coming there. Please restrict to the topic. If you want, we will take the directors again. We have already taken, it was 2 sessions. Again, we will take it, but
in fact, Dipti, to the participants, if I'm permitted to say so, that I think if I'm not wrong, last month Chartered Secretary, I have written an article about managerial remuneration. To a large extent, I have covered these aspects, and the participants, whoever are interested or facing these issues, they may kindly go through that. Still, if they have any issues, they can write to me. My email ID is there in that article itself. They can write to me. I will try to help them out.
Sure, sir. Thank you.
Thank you very much.
Yes, Mr. Hemant.
Recording.
Mr. Hemant, you are there? You raise your hands.
I think by mistake.
Okay, we can proceed, I think.
Okay, Charmi, proceed if he is there.
Good morning, ma'am. Just a small question. During discussion, you were referring to private limited company which are excluded. Does that also mean unlisted public company? Because there are 2 categories of public company. One is listed, one is unlisted. Just can you clarify?
Sir, in case of Companies Act is concerned, public company means it is public company, whether it is listed or unlisted, it is immaterial. Because Companies Act very clearly says listed companies, public companies, private companies, one person, small, all these things very categorically they use the words. So we have to restrict ourselves to that particular wording only. Wherever it Companies Act says public company means it is both listed as well as unlisted public companies.
Thank you. Thank you.
Okay, Charmi. Start.
Yes, ma'am. So continuing forward, a proviso has also been added for taking prior approval of members in case of appointment of previously rejected directors. And they have said that this shall be done only with the prior approval of shareholders, provided that the statement referred shall be annexed to the notice of the shareholders for considering the appointment or reappointment, which shall contain a detailed explanation and justification from the NRC committee and the board of directors for recommending such a person for reappointment or appointment. So now the impact being the prior approval of shareholders is required for appointment or reappointment of a person as managerial director or whole-time director or as a manager who was previously rejected by the members. In such appointments, the justification from the NRC committee and the board has to be taken for recommending such a person for their appointment or reappointment. Coming to Regulation 17A, explanation for maximum number of directorships has been provided here. So it says that for the purpose of this regulation, the count for number of listed entities on which a person is a director or independent director shall only be those equity shares which are listed on the stock exchange. So they have now excluded the private and unlisted public companies and the debt listed companies. So these regulations won't be applicable to them. Also, an amendment has been given in Regulation 25, Subregulation 2A, which states that the shareholders' approval by special resolution for appointment and removal of independent directors are required. Earlier, the practice was followed as companies were passing ordinary resolution for appointment of independent directors and special resolution for reappointment or removals of independent director. However, now they have to take special resolution by the shareholders' approval for appointment, reappointment, or the removal of the independent director.
Yeah, this is going to bring in quite a lot of uncertainty because it's not going to be very easy. Yes, yes. It's
Very
not
much,
going to be
yeah.
always easy to get a special resolution passed. And but let's see how it goes. I think the coming years' experience will be interesting.
So again, here is a harmonization issue between the company side as well as the LODR regulations.
Yeah, exactly.
Yeah, Charmi.
So Regulation 25, Subregulation 3, meeting of independent directors, it says that the independent director shall hold at least one meeting in a financial year. Earlier, a financial year was not mentioned in the provision. So the impact being that a clarity has been provided that one meeting of independent directors should be at least held in a financial year. Regulation 25, Subregulation 6 speaks about the replacement of resigned or removed independent director. So here the new provision states that any independent director who resigns or is removed from the board of directors, he shall be replaced by the new independent director not later than the 3 months from the date of such vacancy. And this regulation shall come into effect with in April 1st, 2022. So now the new independent director has to be appointed within 3 months of his resignation or removal of previous independent director in order to comply with the minimum composition of independent directors on the board of listed entity. Also, a cooling off period for independent director has been provided in Regulation 25, Subregulation 11. It states that no independent director who resigns from a listed entity shall be appointed as an executive or whole-time director unless a period of 1 year has been elapsed from the date of resignation as an independent director. So, however, no restriction on this appointment has been imposed in case of an appointment as an independent director in holding subsidiary or associate company of the listed entity. But he should not be appointed as an executive or whole-time director in the listed company.
This is interesting amendment. Huh?
Hello. Yeah, see, in fact, here also, Dipti, there are 1 or 2 issues are there. What this amendment says is that no independent director who resigns shall be appointed as an executive or a whole-time director, and that 1 year cooling period is applicable. Question comes, suppose if the independent director who has resigned as an independent director, can he continue to be a director? Answer is yes. An independent director whose independence got affected, he may continue to be a non-independent director. He need not resign from the board as such completely, number 1. Number 2 is that suppose this independent director, another question in fact recently posed was an independent director who has completed 2 terms of 5 years each. Can he be appointed as a non-independent director of the company? Again, immediately without any cooling period, answer is yes. An independent director who has completed 2 terms of 5 years each, he can be appointed as a non-independent director in the same company. Yeah.
Yeah, because I think there were a few cases where the independent director, he resigned and then he immediately went on to occupy the position of a whole-time director or managing director in that company. I think just to plug that loophole, I think they have just said that there has to be a cooling off period of at least 1 year. So now it cannot be done automatically. So, I mean, one cannot suddenly switch over from independent directorship to whole-time directorship.
Here, just I think it is technical. They are not telling on the board of the said listed entity, telling on the board of the listed entity. You know, It is.
No, means it is the same company. You cannot.
But actually, I fully agree because they are referring to promoter group also. But clarity
They are referring to
purpose,
the same company, in fact.
Yeah.
It is same company. It is not
Here the word used is the and not a. So when the is
so
used,
specific it is.
Going back to SSB days. Yeah. So the and a, which makes the difference.
Yeah, Sailesh Bhai, yes. Grammar guru.
Not guru, nahi, but
Right. Okay, Charmi.
Excuse me, sorry.
Yeah.
Hello, good afternoon, Dipti madam.
Yeah, Jivan, please, Jivan.
And good afternoon, all panel members.
After a long time, Jivan.
No, I am a regular attendee of your all Saturday seminar, and it's very fruitful, very informative for all of us.
Jivan is ex-Mehta, so I'm knowing him, so I commented. Okay.
Thank you.
Yes, sir.
See, I'm just going two, three slides before about the appointment of independent director by special resolution. I think there was some news report on the SEBI also reports consultative paper where it was required majority of minority. That was also one report which was floating that the SEBI was also interested in getting the approval of majority of minority. Is this still valid or it is?
Yeah, that was.
My question is only a special resolution or also we have to get a majority of the minority shareholders, because special resolution where promoters are holding a majority stake, it will be easier for those promoter driven company to even get through the resolution. But is this the requirement of majority of a minority shareholders also?
No, it was there only in the consultation paper that majority of minority and all. It was not accepted.
No, it is not there in the regulation so far. Although it was only in the consulting paper, once the regulation comes only it will be. As on date, it is not there.
Okay, so it's only in a consultation phase.
Yeah, that's it.
Yeah. Thank you.
Thanks. Charmi?
Yes, ma'am. Moving forward, Regulation 26, Sub-Regulation 4 speaks about non-executive director to disclose the notice of general meeting his or her holding in the company. Earlier, the old provision was mentioned about that the non-executive director shall disclose his holding in the general meeting. Now, this provision is no longer required to be complied with and has been omitted by the SEBI LODR regulations. Coming to Regulation 36, Sub-Regulation 3, which speaks about information to be provided to members in case of appointment or reappointment of a director. It says that in case of appointment of a new director or reappointment of a director, the shareholders, along with the earlier information, shall be provided with the disclosures of relationships between the directors inter se, and also the names of listed entities in which the person also holds directorship and membership of committees of board, along with the listed entities from which the person has resigned in the past 3 years. And it should also mention the case of independent directors, the skills and capabilities which are required for their role and manner in which the proposed person meets such requirements. So the impact being, along with the other disclosures, names also shall be given of the listed entities from which the person has resigned in the past 3 years. And also in case of independent directors, their skills and capabilities are required for their roles and manners in which the proposed person meets such requirements.
Panel, your view on this amendment?
It was there in the year 2020 that they have to work out the skill sets required by the independent directors. The directors are such, and then in 2021 annual report that the directors are to be mapped to those skill sets. And after that, any director who is an independent director, especially whenever they are appointed, that the requisite skill sets, what are required, whether how he is going to comply with that skill set. Say, for example, if an independent director is term expired or he has resigned, there is a casual vacancy. So the skill sets, what has been mapped to that particular independent director, whoever is being replaced, he should match more or less those skill sets what are required. This is what this amendment is concerned, and it's certainly a good amendment according to me.
Yeah, and in view of the special resolution now requires shareholders should be given additional information why they should apply.
Yeah, I think this is one more provision where things are being made a little difficult for the corporate sector, and at the same time, it will, I think, only test the drafting skills of the professionals, and and what skills to be put and what capabilities to be put, etc. I think ultimately it will become a tick box exercise, and one can always fit it within the skills and capabilities required for the role, and then how this particular person meets that skill requirement or capability requirement. Ultimately, I think whoever is to be appointed will be appointed, and the only thing, the company secretary will decide how to fit it within that.
That's it. That's it.
Thank you for your comment, Dr. Sridhar. Yeah.
Thank you.
Charmi.
Yeah, so moving forward, also the regulation 25 subregulation 10 speaks about directors and officers in insurance. Earlier, this provision was applicable only to top 500 listed entities by market capitalization. But now from January 1, 2022, the regulation is applicable to 1,000 listed entities with effect from January 1. So now all the next 500 listed companies are also included in this amendment.
I want to just Charmi, if you can go to previous slide, please. Yes. About this D&O insurance, I want to make a submission to the participants that whenever I go to IOD as a faculty, I always tell them that though regulation says that it is applicable to 1,000 top listed, 1,000 listed entities only, but it is always advisable to have the D&O insurance policy for all companies and especially for all listed companies. Let us see, as KMPs, we have immense responsibilities. Whether you are a CFO or a company secretary, you also have immense responsibilities. And sometimes we also happen that in the holding company we are there, but we may become directors in the subsidiary companies. Definitely, the way the regulations are there, the way the penal provisions are there, which are being enforced also by the regulators, it is advisable to have the D&O insurance policy the way we have our health policies and etc. things. Because for a rainy day, definitely they will come into to our rescue. So that's why we have to emphasize this particular factor to the management and to take this insurance policy also.
I think good point, Sudhakar, that yes, for KMP and all directors, whether listed or not applicable, it should be taken in view of the continuous evolving the legal atmosphere and the responsibility KMP carries. It's a very good point raised by you.
See, most of the, companies, overseas companies who are holding in Indian companies, etc., also see there is always a rule that the private, public, unlisted, listed, whatever it is, they have the D&O policy for everybody, including the company sector.
Yeah. Okay, thank you. Charmi?
So now we'll be further discussing about
Charmi, before you switch over to related party transactions, yes, I want to do a 2-minute advocacy for the Secretarial Standard Board.
Sure.
As Dipti and Raja sir know it very well, I am quite vocal about the Secretarial Standards as well as the guidance notes issued by ICSI. I am always having a concern that the kind of our own fraternity is not giving the importance what they deserve. I always am quite vocal about this particular thing. And the revised guidance note on independent directors was released in the National Convention in the month of January. In the revised guidance notes, a lot of new aspects have been brought in. And to a large extent, we felt that some kind of foxpaws and non-compliances are being taken place in the companies. So my submission to all the participants is whenever you are appointing any independent director or any issue comes, please refer to the guidance note, which has been discussed each and every aspect very comprehensively and very elaborate. Thank you very much.
Thank you. Yeah, Chan.
So with respect to related party transactions, regulation 23 subregulation 1, an explanation has been provided for material related party transactions. Earlier, there was only a limit of 10%, but now the transaction has become more stringent, which says that provided that a transaction with a related party shall be considered as material if the transaction to be entered into individually or taken together with previous transactions exceeds rupees 1,000 crore or 10% of annual consolidated turnover of the listed entity as per the last audited financial statements of the listed entity, whichever is lower. coming to regulation.
I think that has become the most contentious issue now. I think particularly for companies where Mr. Sudhakar is there, etc. For those companies, 1,000 crores is a very, very small figure. And if for 1,000 crore transaction, if they have to go to the shareholders, practically every transaction of theirs could be amounting to more than 1,000 crores. I don't know how they, how RIL is going to handle that issue. I'm really wondering.
In fact, sometimes I feel that the regulator is a bit obsessed with two concepts. One is related party transactions, and the second one is independent directors. Especially in case of related party transactions, it is a double dhamaka. On one side, you have changed the definition of the related parties.
Right.
You brought the related parties of the subsidiaries also to the related parties of the holding company.
Yeah.
And then on the other side, what you have did was this limits actually what has been given as 1,000 crore, as Sridhar rightly mentioned, for bigger conglomerates, it is virtually a pittance, and 1,000 crores is nothing. That means every now and then you have to go to the shareholders, and you are putting the companies into some kind of a difficulty, according to me. It is
and again, where the
one is the part of the compliance. One is part of compliance, and second thing is we are talking about ease of doing business.
Doing business.
On the other side, if you see that this is not in ease of doing business, it is definitely affecting, according to me, the continuity of business sometimes. Because see, what happens is it is very, very difficult to explain that every related party transaction per se is not abusive. Yeah. But how to explain that?
Perfect.
Because I always say that independence is a perception. The independent director has to exhibit that at any point of time he is independent. Same is the case here also. Related party transactions are, every transaction need not be abusive. And to a large extent for big conglomerates, related party transactions are always welcome features.
Yeah.
As far as the deliverables are concerned, as far as the quality is concerned, as far as the pricing is concerned, no doubt about it, some black sheep may be there here and there and all. They might be fleecing the company for their own benefit and all. But that doesn't mean you scale everybody with, you measure the same, everybody with the same scale, which is not fair according to me.
I fully agree with Mr. Sudhakar on this. And I think to paint everyone with the same brush, I think is not correct. And 1,000 crores, even for companies with say 40,000 crore turnover, 50,000 crores, it would be a very tough thing. And of course, for a company like RIL, it will be too much. And this 1,000 crore limit should definitely go away. We hope SEBI will listen to the representations made and then will remove this limit. But of course, as Mr. Sudhakar said, we'll have to keep our fingers crossed whether they really make any change here. But if they make the change, I think the 10% of the annual consolidated turnover was perfectly fine. I think we should probably stick to that only, and this limit of 1,000 crores should be removed.
In fact, I am confident that definitely this will undergo a change. If you remember in the Companies Act also earlier, for 188, there were threshold limits were there. There they used to set 10% of turnover or 100 crores, whichever is less. But ultimately, that the regulator appreciated that, and they have removed that 100 crores figure from the Companies Act altogether. They have just the 10% of the turnover or 10% of the services rendered or availed, like that it is so. I'm sure that the way Companies Act rules were amended, Rule 15, if I am not wrong, that one, the way it was amended, it will also come. It is only a question of time, whether it comes before 31st March or not. It seems to be not clear. That's why several companies have already started taking the approvals by way of postal ballots.
Correct. And again, that is a double whammy because again, the related parties cannot even vote. And it is not even just the concerned related party, all the related parties will be ineligible to vote. So which means it's this is where that majority of minority will come in.
Correct. Now the question is, material RPT earlier approved for 3 years still valid? Whether fresh approval is required?
If it is specifically mentioned in that explanatory statement as to the tenure and everything, then that should be fine.
till the time there is no change in the earlier transactions, they can, I think, they can continue. But if a slightest change is going to be there in that, whether it is pricing or deliverables or anything else, any kind of amendment to that, definitely this will get triggered.
And the other point is, if it is a material modification as will be defined by the audit committee, if it falls within that category, then again they will have to take a prior approval of the shareholders.
Yeah.
So whether it becomes a material modification or not will be the main point to be considered.
Okay. I think earlier one question is skipped, so that Mr. Sivkumar has repeated. Can an independent director of a wealth management services company be called as an independent director if that independent director's wealth is managed by this company, which is in its ordinary course of business?
If I'm permitted to say that, these kind of questions we cannot just give on the answers on the webinars, and not to be sought also, because we have to examine a lot of aspects, interlinked aspects to that. So that's why my advice to the questionnaire is that it is always to be examined based on the facts and figures. So, otherwise, it should not simply say yes or no, and the participant should not go as per whatever the panelist says also. Because we are saying here without any kind of obligation as such, except that kind of image what we have, that's it. So it depends upon what kind of facts and figures. But if you want my answer on the face of it, it seems to be answer is no. Face of it, but don't take it as granted.
Depends on facts still.
Correct.
Yeah, absolutely, absolutely.
Okay, thanks. Charmi?
Shiv Prakash has raised the hands, I think. Shiv Prakash, you'd like to ask something?
Yeah, sorry to interrupt you, sirs. Basically, my question is general in the nature about sourcing of independent directors. What we do is through our own sources, we try to have a person. There is an Institute of Independent Directors database. So I just wanted to have your experience. Is the sourcing being done from that database, or it's only for the namesake the database exists?
I think, Mr. Seproma, the topic is not pertaining to the topic we are talking.
No, it's about independent directors, the change which was shown before.
Okay, panel, just in 1 minute.
Anyway, just to answer his question, no doubt about it, the data bank is maintained by IACA, and similarly the data banks are maintained by ICAI, ICSI, as well as IOD also. Whether you are sourcing or not, it all depends upon the companies, and the resources are without any kind of obligations. And at the end of the day, the question comes that, to my knowledge, merely people will not be taken from the data bank. It is always because you are inviting an unknown person to your boardroom. The sanctity is to be maintained, so a lot of due diligence is to be conducted as far as the incumbent is concerned. But yes, suppose sometimes it may so happen that you want a director from a particular skill set or a specialization factor. So people do definitely depend upon the data bank also. It is not like that. You cannot say to a large extent it is not so, but to some extent it is so.
We can say that for sourcing, for checking the kind of people available, and then checking the profile, then understanding, then meeting the people, then of course it will be. So it is a data bank, basically.
Yeah, I think it is a data bank, and I very much doubt if the big groups would really rely on those data banks. And probably for medium-sized companies and smaller-sized companies, probably they may take assistance of that. But I don't think any of the big companies will ever go into the data bank, because ultimately they'll go by their own contacts, their own resources, and then ultimately they have to have comfort with that particular person, and not based on biodata of a particular person. So I very much doubt if that the database is really useful for any of the big companies.
Thank you, sir.
Thank you. Thank you.
The comfort.
Yeah. Okay, thank you. Charmi?
Yes, ma'am. Also, an amendment has been provided in Regulation 23, Subregulation 2, which speaks about approval of audit committee to related party transactions. Earlier, the provision had said all related party transactions shall require prior approval of the audit committee, but now they have added that all related party transactions and also the subsequent material modifications shall be requiring prior approval of the audit committee, provided that only those members of audit committee who are independent directors shall approve these related party transactions. And what is material modifications? That can be defined by the audit committee of a listed entity, and it can be disclosed as a part of their policy on materiality and dealing and of related party transactions and on dealing with related party transactions. A related party transaction to which a subsidiary of a listed entity is a party, but listed entity is not a party, then it shall require prior approval of the audit committee of that listed entity also, if value of such transactions, whether entered individually or taken together, exceeds 10% of the annual, of the annual consolidated turnover as per the last audited financial statements of the listed entity. And with effect from 1st April 2023, a related party transaction which is a subsidiary to which a subsidiary of a listed entity is a party, but listed entity is not, then it shall also require prior approval of audit committee of the listed entity if value individually or taken together with previous transactions exceeds 10% of annual stand-alone turnover during a financial year. And also prior approval of the audit committee of listed entity shall not be required for a related party transaction to which the listed subsidiary is a party, but listed entity is not a party.
1 minute. There is a question in the chat box. What is material modification? The same is not defined. And it is mentioned, it is answered also by another participant that in the consultation with management, audit committee has to finalize.
No, see, see, as far as this material modification is concerned, in the regulation itself, it is very clearly there. You have to address what is a material modification as a policy. In the material related party transactions policy, the board has to address this issue. That means the board has to give a guidance to the audit committee. Based on that, the audit committee has to decide what is a material modification, and accordingly, the management has to deal with that. It is not a question, because here management doesn't come into picture. It is an issue between the board as well as the audit committee.
Absolutely correct. And the audit committee will have to define it, and that definition will become part of the RPT policy.
Yeah. Another thing that Sudhakar mentioned, it's like, you know, they are obsessed, RPT and independent directors. Stricter. Okay.
And of course, the material modification, how to define would be a question which can come up from the participants. Say, for example, some people might do it in terms of percentage. Some people may do it in terms of value. Some people may say higher of the two, or some people may say lower of the two. So ultimately, one has to take a call as to how to define the material modification. And if you ask my view, I would say material modification should be both in terms of percentage as well as in terms of value, and say whichever is higher. So to make it safer, and because if it is a small value item, the percentage maybe it may not be sufficient, because even a slight increase, say suppose on a 1 lakh RPT, even say if you are going to put a percentage of 10% or 20%, and if it is 21,000, then it can become a material modification requiring approvals of the shareholders and so on. So better to put the percentage as well as the value, and say whichever is higher.
In fact, I fully agree with Sridhar. See, this material modification thing, the regulator has left it to the corporates to decide it. Okay. And I always used to say that if I'm regulated, I am always happy. But self-regulation is a problem for me. In the self-regulation, what happens is,
yes.
If you are liberal with you, you will be in difficulty, you know. So that's why, in fact, in the Companies Act 2013, if we compare with Companies Act 1956, 1956 was a regulated act, and the 2013 is a self-regulated act. So always I used to say that considering the penal provisions, whenever you are being given a benefit of doubt, don't avail the benefit. In fact, as far as the SEBI listing regulations are concerned, especially when we used to discuss with Regulation 30, what is the materiality of the disclosures to be given to the stock exchanges, I used to say at that point of time, in fact, I still remember Khusro Balsara's words, when in doubt, disclose. That is the mantra the stock exchanges used to say always. So here also, material modification, what exactly is the material? As a compliance officer and as a key managerial person, it is your responsibility to advise the board what is materiality in the modification. Okay. And we should not just leave it to the board also as such. And we as KMPs, we do have a role to play in that.
I really appreciate Sudhakar this point, really rightly pointed out.
In fact, you see, Dipti, let me also add one thing. Sometimes these kind of things are very, people say that it is easy to say in the conferences, but very difficult to do it in the boardrooms. But the way the things are happening, the regulators are roping in the KMPs also. They say it is your responsibility as compliance officer and key managerial persons. So if you are shying away because of the inhibition, because of the fear or whatever it is from the boards, then you will be in trouble and you will put your board also in trouble. At least we should be able to articulate before the board what is what and what is to be done. The rest, of course, we have to leave it to the board only. We should do our duty.
I think absolutely agree with Mr. Sudhakar. So basically, if the intentions are good and also we have to see the practical aspects, and if you take everything into consideration and then define it suitably, then that should be fine. But if there is a bad intention, bad motive in defining it and then trying to get away with some shareholders approval or audit committee approval or board approval, that may not be the correct thing to do. But if the intention is to, of course, have proper and reasonable restrictions and reasonable definitions, and then at the same time, a little practical and prudent way of doing it from the finance department's point of view or the company secretary's point of view, etc., then that should be fine. So basically, I think the intention and the motive would be the most important part.
Yeah, somebody has asked question whether it will be effective, amendment effective from 1st January 22. So,
22, yes.
Yes, it will be prospective.
Yes.
Okay, next, Charmi.
I have two questions, please.
Yeah.
Sir, I have two questions. This material notification is a very, that's not so easy because first of just Sudhakar said just told it is a duty of the compliance officer or the KMP to advise the board. What would be the reasonability of the materiality? Suppose 10% is reasonable. Can it be if 60% more than 50% be tantamount to be reasonable? If board chalo bhai 50% karke kar do isko. Is it tenable?
Yeah, in my view, for example, like accounting standard significant influence, they say 20%. So I would say 20% is reasonable. I think nobody would question it much. But of course, one may want to make it 10%, but then it might make too many things getting covered there by modification. So at the same time, making it 25% or 30% or 50%, etc., may not be acceptable to the regulator. Or
it all depends upon it all depends, as Sridhar has rightly mentioned, it depends upon the value as well as the percentage also. Suppose if the transaction is a 100 crores transaction, and the modification to the transaction is supposed to have 10 to 15 crores, for a company of our size, it might be pittance. But for a small company, it might be very big. So that's why this, in fact, regulator, according to me, rightly he did that. He left it to the corporates to decide that. They have not defined that. Same is the case, in fact, in section 188 also, when they say it in the ordinary course of business and at an arm's length. The definition of ordinary course of business has not been given by the regulator. In fact, at that point of time, there was a lot of submissions have gone to the regulators that please define what is ordinary course of business. I was telling that point of time on the roof, from the rooftop, if the regulator defines it, it may not suit you. You know what is ordinary course of business better than anybody else. Why you are craving for that definition? Same is the case here also. You
Right.
have to go understanding your business, your size of business, the dynamics of the transaction. It is for you to decide it. You means as the compliance officer, the KMP, compliance officer, and the board together.
Okay,
You have to decide it.
The last question. The last question. The threshold of 1,000 crore. It means whenever the company is in opinion that this transaction is crosses 1,000 crore, we have to take approval of shareholders, prior approval. Suppose I have one material subsidiary company with continuous basis, we are doing transaction, and it is 1,000 crore is cumulative of all the transaction, not a single transaction. Okay,
Correct.
sir. Suppose I am in opinion it would not cross. But however, after July or September, we feel that now is going to be exceed in the month of December. So at that point of time, we can go to shareholders and get approval.
Yes,
Before
definitely.
entering into the transaction, you have to be proactive.
Yeah.
So you have to keep
in fact,
monitoring the figures constantly, and you have to ensure that well before you reach that threshold, you have to be ready for taking the shareholders' approval.
So you should have proper communication with your accounting and operative team also to give them instructions so that that information is obtained by you, right, Sudhakar, this way.
Yeah.
And
In fact, recently somebody asked me this question, sir, it is including GST or excluding GST? So on one side, if you look at it, the question is very innocent question, simple question. On the other side, if you look at it, it is always better to include every damn thing. In fact, pardon my language, but you have to see when you're taking the approval, why you have to shy off when including GST, excluding GST, and all those things. Combine everything. Okay, if you want to just keep by suppose 100 crores is the transaction you are envisaging it, take an approval for 125 crores. It is always you have to be proactive because you cannot go back to the shareholders once again. There are two issues are here. One is the cost. Second thing is that you have to get the approval of the minority of majority. Related parties cannot vote. Please remember that.
I remember the income taxes, whenever the TDS provision was there, people used to split the transaction into differently so that in order to avoid the tax.
Correct.
Okay, Charmi, next.
I think Richa has raised the hand. You have any question, Richa? Richa Agarwal?
Yes, sir. Thank you. So one quick question. Under regulation 23.2 and 23.4, material modification is mentioned twice. Now, are the corporates expected to have different limits when it comes to material modification for shareholders and for audit committee, or it should be the same one?
Yeah, in my view, it can be different. It can be the same also. It can be both. So ultimately, the audit committee will have to decide. But generally, I think material modifications could be one single definition, which will be applicable for both audit committee as well as for the shareholders. But I think Mr. Sudhakar may give us views.
Sir, what is the question, Sridhar? In fact, for a moment, my attention got diverted.
No, whether the material modification, whether the definition has to be separate for the audit committee approvals and separate for the shareholders approvals.
No, sir, it should be one and the same.
Yes.
How can it be two when that's sir, sorry, the material modification has to be properly defined in the policy of materiality, and that is shall be approved by the audit committee. Accordingly, it would be applicable for both in the same.
Now, if one wants to draft it, we can always draft it in such a way that for the shareholders, the material modification is different. But generally, it is not expected to be different. It is expected to be the same. But of course, you can always have your drafting skills to make it different.
Okay.
See, every transaction is to be approved by the audit committee, prior approval of the audit committee. And only material modifications you have to go to the shareholders. So material modification is only one definition, that is for the purpose of going to the shareholders. Okay.
Correct.
Yeah.
Okay, Charmi.
One more hand raising is there from Naveen. Yes, Naveen.
Yes, sir. Thank you. So, sir, I have a question that in case of the material RPT limit of a company is 1,000 crores and material modification defined by the audit committee is 10%. So, does it indirectly mean that company can do transaction of 1,100 crores without obtaining shareholders' approval?
Can you repeat the question?
Yeah, so sir, the RPT limit, material related party transaction limit of a company is 1,000 crores.
Yeah.
And the material modification defined by the audit committee is 10%. So does it mean that the company can do transaction of total 1,100 crores, 1,000 crores plus 10% in the financial year without going again to the shareholders for that additional 100 crores?
No, 1,000 I think is the upper limit. So that includes the modification.
Okay.
Sudhakar, you have any other view?
No, I agree with you for that.
So sir, then this material modification, whether it will have any practical impact, like if only the other terms, the qualitative terms, if they are amended or there is modification in those, only then it will be applicable. Does it mean that?
The material modification does not mean you will exceed the value of the contract.
Right.
See that, because suppose if it is X amount is there, say for example 1,000 crores or 2,000 crores, that is the upper limit which has been approved. Within that limit, you can do whatever you want to do it. Suppose sometimes what happens is that price what you are deciding it per unit, that may change. That may be material modification. So the terms of contract, if they are materially modified, that again it requires the shareholders' approval. That doesn't mean that upper limit of the transaction, you cannot exceed that.
Right, sir. Thank you so much.
Yeah.
So one more question. For this prior approval of the shareholders, so in case of a company, for example, it is envisaged that in the subsequent financial year, this 1,000 crore limit is going to be breached, but there is no written contract. It is transaction, a number of transactions will take place. So whether the prior approval is to be taken before the commencement of financial year, or when the limit actually is breached, or it is about to be breached.
See, if we are taking the approval of the audit committee on omnibus basis, omnibus transactions are also to be approved before the financial year starts. Because every transaction RPT in case of a listed company should have the prior approval of the audit committee. Even if you cannot enter without the approval of audit committee any transaction on 1st April. In fact, sometimes most of the companies, they say that in the month of May, I have my board meeting and audit committee meeting. I will take the approval on omnibus basis and I will ratify the transactions from 1st April to the board meeting, date of the board meeting. It is not correct because it requires prior approval of the audit committee. So what happens is that maybe you have to take the approval in the January board meeting, or alternately have another board meeting in the month of March for omnibus approval. Though it is permitted under the Companies Act that audit committee can pass the resolution by circulation, but approving the omnibus or related party transactions by way of a circular resolution, certainly governance point of view, it is not appreciated.
Sir, the same question in case of material RPT, whether shareholders approval also we need to take by postal ballot or other means before March.
Everything is prior approval. You take it by postal ballot or you conduct a general meeting. It all depends upon you, but it should be a prior approval.
But even if there is no contract, sir, still like if my limit will be breached, say in the month of July or August, so still I have to take before April or before August?
Technically, according to me, you cannot enter into a contract also without the shareholders' approval. You can enter into an MOU kind of thing.
Okay.
Where is the authority otherwise to enter into a contract? Tomorrow, suppose shareholders won't approve and you have entered into a contract, it will be a big problem for you. You may have to pay damages, whatever it is, all those things at that point of time if you are not able to execute the contract. So it is always advisable. You may have a kind of informal negotiations, maybe enter into an MOU kind of thing without binding, but you have to have proper authority in place before you are executing a contract. That's what my view is.
Absolutely correct. Absolutely correct.
So thank you so much. So last, just further question to this only. So if there is no contract, if there is like only the purchase orders or something are raised, there is no specific contract, whether the same guidance will be applicable that
raising a purchase order itself is a contract.
Purchase order itself is a contract, no?
Yeah, but sir, so purchase order will be of a smaller value. It will not breach 10%. 10% will be breached, say, in the month of August, as I said. So whether still we have to take before August or before April, that is where we are stuck.
Okay, suppose if you want to say like that, before I cross the threshold limits and all, that point of time, have the prior approval of the audit committee. Till the time you reach the threshold limit, no doubt about it, you don't require shareholders approval. That is very clear. That means it is not a material related party transaction, no? Unless until you trigger the threshold limits, it is not a material related party transaction. So for RPTs, what happens? You require prior approval of the audit committee. Take the approval of the audit committee and go ahead. But as Mr. Sridhar has rightly mentioned, that when you have to be very clear, you have to be keep a track of that. When you are going to hit the threshold limits, and much before that, you should be able to have the shareholders approval in place.
Correct.
Yep.
Thank you so much, sir. Thank you so much, everyone.
I think Rohit and Manoj, they also raised the hand. Yes, Rohit.
Sir, in fact,
So, sir,
sorry, Bala sir, before the participant put the question, one more thing I want to add here is that, in fact, in one of the forums, I have been asked this question that I have entered into a contract for, say, 800 crores. And because of the circumstances or whatever we may call it as and all, there is a price escalation in that, and the escalation was inbuilt in the contract itself. Now, this thing is crossing the 1,000 crores limit and it is becoming a material related party transaction. What should I do for that? That was the question which was posed to me. Answer to that is, whatever it may be, if it is crossing the threshold limits, it becomes a material related party transaction. Even certain times it may be a force majeure also. But still, if it triggers the limits, you have no other option but to go to the shareholders, have their approval, and then do it.
And one more point I may just want to add. I think, of course, most of you must have already noticed that 22nd November circular of SEBI clearly lays down what is to be placed before the audit committee for review for any approval of RPTs. And they are given a long list of things to be placed before the audit committee, like the material terms, the type, the particulars of the transaction, and then tenure of the transaction, value of the transaction, percentage to the annual consolidated turnover, and then if it relates to intercompany deposits or loans, etc. Again, big list of requirements, and then what are the terms, applicable terms, covenants, tenure, interest rate, repayment, and so on. Justification as to why RPT is in the interest of the listed entity, and a copy of the valuation report also to be placed, and percentage of counterparty's annual consolidated turnover, which mercifully is only voluntary. And there are some other information which also may have to be placed before the audit committee for review. This is required to be done for every transaction which is placed before the audit committee. And similarly, information to be provided to shareholders for consideration of RPT is also long list. Everything that is placed before the audit committee plus various other things you will have to mention, and a lot of things have to be placed before the shareholders as well. So these are fairly difficult compliances to be carried out.
Dr. Sridhar, there is a question that whether this has to be placed for prospective transaction, not existing. No, that is the question, right? Yeah. Prospective. Yes.
Okay. It is all prospective, but at the same time, 1st April 2022 is not far away from today. So ultimately, it has to be done now. So 1st April 2022, it becomes applicable. And since everything is going to be prior approvals, so omnibus approval will have to be done before 31st March, as Sudhakar also mentioned. So you don't have much time in case you are not already done.
Okay.
So I have a question. Material modification limits which are approved by the audit committee for shareholder approvals is a concept that is introduced by LODR. If the transaction is also getting triggered under 188, there is no such material modification threshold or a buffer zone which is provided by the Companies Act. Correct. So do we assume that the LODR threshold which is approved by the audit committee could also be used for for certain limits which are exceeding in the past resolutions passed for 188
Yeah,
or the new ones as well.
Yeah, 188 anyway is not talking about material RPTs. So here we are only considering material RPTs under the LODR. So to that extent, if you are anyway taking under 188, it is for a different type of thresholds, and here it is different.
No, sir. So, for example, suppose supply of goods and material or services between two related parties. Now, that is something which the 188 also lays down a threshold, let's say 10%, while LODR might say 1,000 crore.
No, but where it is in the ordinary course of business and an arm's length, it's not required. So where it is not an ordinary course and not an arm's length, only then that requirement is there under 188. No?
Yes, sir. So assume that we are not able to establish.
I must say one thing. In case of 188, the rule said 10% of the turnover. It is standalone, not consolidated. Whereas here, in case of listing regulations, for the purpose of material related party transaction, it is 10% of the consolidated turnover of the company. Okay, so there is a difference, number one. Number two is that whenever the approval of the shareholders is to be taken, you have to comply. If it is a listed company, it has to comply with Regulation 23 as well as the Section 188 and the rules thereof. And to some extent, the disparity is there in between both these regulations. Say, for example, as Mr. Sridhar has rightly mentioned that in the case of ordinary course of business and arm's length, the transaction is exempted from board and shareholders approval under the Companies Act, which is not the case as far as your listing regulations are concerned. Similarly, in case of listing regulations, whether the price is charged or not, it is immaterial. You have to have the approval of that audit committee or the shareholders, whatever it is there under Regulation 23. So it is a different ballgame altogether. And in fact, in one of the forums, I myself has raised this issue before one of the SEBI officials. And what I have been told is that these are two different platforms as far as the Companies Act is concerned and SEBI is concerned. SEBI's responsibility is to tackle the companies which are listed on the stock exchanges. So sometimes it may so happen the regulatory measures may be on slightly higher pedestal. That's what their expectation is.
Again, who cannot vote? Again, there are differences. There it is only the related party who is party to that particular transaction cannot vote. Whereas for SEBI purposes, all the related parties will be ineligible to vote. So again, that is another major difference.
Sir, good afternoon. My name is Manoj, sir. I have a question.
Yeah.
Sir, if you look at the related party definition effective from 1st April 2023, it says purpose and effect of which it is to benefit related party of a listed entity or a subsidiaries. So from an independent director's point of view, how am I going to suppose to look at this provision? Should I just rely upon the comfort letters given by the management? One question. Second is, as a secretarial auditor, how I'm going to review this transaction?
Yeah, very true. I think it is pretty difficult. I think you will have to go by the management certificate, and the management also will have to take some certificates. I think ultimately it is impossible to know whether any particular transaction is likely to have indirect benefit to any other related party. So we have to take maybe a declaration from the executive director, managing director, or maybe the CFO, or a few others, or maybe the purchase department and commercial department, and based on that management certificate, maybe the secretarial auditor will have to give the certificate.
Absolutely right. Absolutely right, Doctor. Yeah, it is always the management letter. Independently, we cannot check.
One thing is there, in fact, sometimes if the panelists are in agreement, that means it is a kind of a match fixation is there. So here I slightly disagree with Dr. Sridhar. If I am the secretarial auditor, I will simply not bank upon the management letters. I have to be vigilant enough to understand that what is the transaction like. As secretarial auditor, I cannot simply wash off my hands. I have no means to verify this transaction. You have to do that, because when I was doing my articleship, I still remember my principal told me, don't see what you have been shown. and don't listen what you have been told. Similarly, he also advised me, try to listen with your eyes and see with your ears. I still remember these words. So as secretarial auditor, though it is easy for me to say, maybe difficult for you to do it, because your management backup certificate is only a kind of a solace for yourself, not for the regulator. As far as the regulator is concerned, he will examine that how vigilant are you. God forbids if you tomorrow the question comes. If you are vigilant enough, if I am able to establish it that you have taken all kind of precautions and all, you will be absolved. Otherwise, you will be held responsible.
Yeah, and another lesson that we learn in that CA course is that you have to be a watchdog at the same time. You cannot be a bloodhound. So
absolutely.
So we have to keep a watch. No
Sudhakar,
doubt.
answer to you. He is giving.
that is true, but all said and done, practically it is very, very difficult, you know.
Yeah.
Because the type of industry, type of organization, type of a thing. As a third person,
primarily, what is the objective of this? Objective of this is nothing but to curb the round robin transactions.
Yeah.
Okay. If I cannot directly enter into, I will do it indirectly.
Correct.
This is what is the objective of this. So how much you can see, you will be able to. Otherwise, you cannot see beyond that. Then obviously, you will not be a party to that. So that's why you have to be vigilant. You know, that's it. That's what I told. Nothing beyond that.
Only one question will take. I'll request participant to now put in chat box so we can take combine also. Omnibus approval transactions by audit committee taken in March 22 for financial year 22-23 should include the new requirement notified by SEBI in November 21.
Yes. Yes.
Yes, of course it should be.
Yes,
okay.
It has to. Yeah.
Okay. Charmi, next. I'll request now participant to put in chat box so that we can complete the presentation, please. Humble request.
Yes, ma'am. So coming to regulation 23 sub-regulation 4, along with the approval for audit committee, it also requires approval of shareholders for all the material related party transactions and subsequent material modifications as defined by the audit committee under the sub-regulation 2. Provided that the prior approval of the shareholders of a listed entity shall not be required for a related party transaction to which a listed subsidiary is a party, but the listed entity is not a party. And an explanation has been provided that for related party transactions of unlisted subsidiaries of a listed subsidiary, the prior approval of the shareholders of the listed subsidiary shall only suffice. Coming to regulation 23 sub-regulation 5, an exemption has been provided from the approval of audit committee. It states that the transactions which have been entered between two wholly owned subsidiaries of the listed entity, listed holding company whose accounts are consolidated with such holding company and placed before the shareholders at the general meeting, they shall be exempted from taking the approval of audit committee. Coming to regulation 23 sub-regulation 9, which states about the disclosures to RP. Here a timeline has been provided that the listed entity shall submit within 15 days from the date of publication of its standalone and consolidated financial results for the half year. Disclosures of related party transactions on a consolidated basis are to be provided to the stock exchange, and it should be published on the website as well. Now,
okay,
1 minute, Charmi.
Charmi, 1 minute. Before you go further, I think we have missed one issue somewhere, that the related party transactions are to be approved by the independent directors of the audit committee. That has not come anywhere here. I don't know why it is so.
No, that has come in the earlier. In fact,
earlier one. Yeah, it came in the earlier one.
That time she said.
Yeah, it can be said actually it should be approved only by the independent director. That
okay. See, this is another peculiar situation that related party transactions are to be approved by the independent directors of the audit committee. Means if a non-independent directors are there on the audit committee, even if he is not an executive director, but still he cannot approve the related party transactions. Now, this is an enormous and arduous responsibility which has been entrusted upon the independent directors who are part of the audit committee. Again, this is going to cause an issue according to me, because they will not be bold enough to approve the related party transactions now onwards. because they know it very well. Number one, as independent directors, their existence itself is always under the radar. In addition to that, they are going to approve the related party transactions. It is again that double yummy kind of thing, you know. So there will be a lot of hesitation from the independent director side as far as this is concerned. In fact, in one of the IoT forums, I have been asked this question: as independent director, how I have to face this situation? I said that the answer to that is only you have to spend more time now onwards and the audit committees. You cannot simply approve and all and pack up within 1 hour. You may have to sit for the whole day, call the concerned people, get educated on the related party transactions, and wherever you feel like as audit committee member, you are within your power to consult a consultant also wherever it is so required. Justify the transaction, get the transaction justified, you get convinced before you give the approval. So this is a slightly tricky situation, which I mean, the regulator has put in the corporates. Sridhar, you may also give your views on this particular issue.
Yeah. I fully agree with you. And another thing is that it goes against the very foundation of the Companies Act, where it says that every director has got a fiduciary responsibility and liability. And then here you are saying that a non-independent, non-executive director or any other director cannot even vote or cannot even consider the audit committee, the RPT transactions and so on. So I think it is again quite contrary to what is there in Companies Act, because every director has got a fiduciary responsibility, and how he is being made to be away from considering these transactions, that is also incorrect.
In one of the forum, I was told that independent director, you know, the person who do related party transaction, do not vote, do not participate, and independent director has to decide everything. And if don't perform, he is only punished. So someone is doing someone is doing. He said independent director is not doing anything. And then he has to dig, he doesn't do, he is also responsible. The person who is doing related party is not active, is not voting, he is not responsible.
In fact, Sridhar, when I was talking to you, one thing has come to my mind now. This I have not, it has triggered with me earlier. See, audit committee is constituted not only under the listing regulations, it is constituted under the Companies Act also.
Correct.
Under 177 also, the prior approval of the audit committee is required for related party transactions. So their audit committee means the entire, all the members of the audit committee, they have to give their approval. And as far as listing regulations are concerned, only the independent directors have to give the approval. How will you match these two situations?
You are taking public money, no? That's why.
No, again, there is no harmony between the two provisions. No, comply with both. You cannot comply with both the provisions.
But how to do this thing is a challenge. Actually, how you will minute that in the audit committee minutes, because under the Companies Act, you have to, entire audit committee has to approve it. Suppose if I have 3 members, say A, B, C, A, B are independent directors and C is an executive director. Under the Companies Act, A, B has to approve. Of course, majority always approves it. That is a different question, not about at all. Okay. So, and as far as your regulations are concerned, listing regulations are concerned, it is only A and B have to approve it. So it's a slightly tricky situation. The minutes when we are drafting it, this issue will definitely come up.
Yeah. I think this is also another matter which we should represent to both the ministries, and then they have to actually do some harmonization.
Yeah, there is a question.
Sorry. Yeah, go ahead.
There is a question that a foundation formed by listed entity for carrying out CSR activity, does contribution transfer to it constitute RPT and to be disclosed to stock exchange under regulation 23(9)?
It is an RPT.
Contribution to what? The contribution to trust, is it?
Yeah, formed by listed entity.
Okay. No, once it is a trust, then that is not a related party. So then need not be disclosed.
Okay. Okay.
Dipti, only one question is that we are just concluding, I think if I am not wrong, the related party transactions, it is already 10 past 1. And if you see the attendance, 223 to it has come down to 170.
171.
171. Okay. So we will not be able to complete the entire presentation today if I am not wrong.
Correct,
How we are going to decide about it.
Yeah. Charmi, how many slides are left?
Ma'am, 25 to 30 slides are left.
Sorry, how many?
25 to 30 slides, ma'am.
I think
What do you suggest?
I think probably we will not be able to complete it because it is
Then
already.
we should take up next week.
Yeah,
next Saturday?
I think so. Next Saturday we should continue this session.
Only I have a difficulty on next Saturday. Next Saturday I have the SSB meeting. Okay.
Yeah, Sudhakar, actually, I am also the.
Yeah, you are also there, Sridhar. Yes. You are also there. So we both are there.
Also just called up.
So what we do, we 1:30 will close, but we will run through the PPT. I will tell participants to put questions on chat box and we will attend separately and mail it to everyone.
See that the next one is committees. Committees may feel again risk management committee is there. If you want to discuss it, is definitely going to take time because risk management committee is completely overhauled by listing regulations amendment.
Right.
Okay.
Because the next topic is also very important because committees, honorable responsibility has been thrown upon the independent.
Yeah. Very subjective.
Yeah.
So we can have it on 26th if it is okay with you because that time we can block our date.
Or I have to postpone because 26th I have booked the meeting. I'll just check because on Social Stock Exchange I'm bringing Mr. Hemant Gupta and the panelist is final.
Okay, check it out. Otherwise, next Sunday also I'm okay. In case you want to hold it next Sunday.
Okay, let's do it. We'll stop here and we will specify the regulation and take one Saturday where both of you are available that way.
Sure.
Yeah, 26th I am also not available. 19th, both of us are not available.
We will take it up again and continue to and write to participant continuation of this webinar only.
Sure.
Okay. We'll take a fresh date from both of you.
Thank you.
I think that will be better because we will have the benefit of this to eminent panelists.
Yeah.
Because I think that will be much better. I think we'll take it another session when they are available.
Yeah, so all participants will come back to you with the date for the leftover presentation and the discussion and the questions.
Charmi, this is the last slide in the RPT.
Yes, this is the last.
Yeah. This is C has already covered all.
Then in which case I think we can stop here. I believe.
Okay.
Yeah.
Okay.
And let me acknowledge Dipti that it is an excellent forum. I really enjoyed while discussing it and look forward for the next session where I'm going to be invited for the remaining part of this one.
Thanks.
And future sessions wherever I'm doing this thing. Thank you very much once again.
Thanks a lot. Thanks a lot very much to Sudhakar and Sridhar for your excellent sharing of the practical experience.
Thank you so much.
And definitely it is adding a knowledge to everybody. I am also learning today, even at the age of 74. So definitely it's a very good deliberations today. I think we look forward to meeting you again in another session. Thanks a lot. And I would like to also compliment to Charmi for an excellent presentation, putting the thing nicely, giving the old version with the new version with the impact. You have done a very good job, Charmi. Congratulations.
Absolutely.
Thank you.
Absolutely.
Thank you, both the panelists, Dr. Sridhar, Sudhakar. Thanks a lot for your time. We'll work out another session for balance topic. And thanks all the participants for your time. Thank you all.
Thank you so much.
Thank you. Bye-bye.